Welcome back to our podcast, MediPocket Surrogacy series, where we explore all the incredible paths to parenthood. I'm your host, Dr. Priyanka Mathur, physician and founder of MediPocket Surrogacy USA, a physician-led high-tech surrogacy agency based in Los Angeles. We support families worldwide in navigating their parenthood journey with compassion, medical excellence, and global expertise. Today's episode is very special. We are diving into the legal side of the surrogacy, the framework that protect families and make this life-changing journey possible. And to guide us through it, we have a true expert. He's an attorney with over 25 years of experience, a fellow of Academy of Adoption and Assisted Reproductive Attorneys, and a recognized super lawyer by Thomson Reuters since 2016. His firm, Tsong Law Group, has helped build countless families through assisted reproductive technology. Please join me in giving a warm welcome to the founder of Tsong Law Group, Mr. Ralph Tsong. Ralph, thank you so much for being here with us today.
Thank you, Dr. Mathur. Thank you.
You have had such a remarkable career from government law to public interest, and now helping families create their future through surrogacy. So, what drew you so passionately?
Well, my wife and I, when we were married, we had trouble having a child of our own. So we, maybe after 3 years of trying, we went to an IVF physician. Actually, we tried the various infertility treatments, herbal treatments, and then finally going to an IVF doctor and doing several cycles and some frozen embryo transfers. And in the end, we were not successful with those procedures. But at the same time, surrogacy was still there. Like, we knew that it was happening. It wasn't something that was within our reach because I was a government lawyer at that time. But, I always I always had surrogacy in my mind. We did eventually successfully have a family. And I wanted to pursue the type of family formation law that was building up families when I started my own law firm back in 2016. So it was kind of a natural fit for me because we had our personal experience with IVF and we knew about the process. So that gave me kind of an advantage in understanding all the steps that happen in a surrogacy arrangement. And we still try to help out people who are like me, because we know that not everyone can afford surrogacy. So we try to find ways that we can help people afford surrogacy as well.
Now,
Surrogacy,
one of the biggest fears intended parents have is, will I really be recognized as the parent? And what are the most common misconceptions people have about surrogacy law?
what you just mentioned is probably one of the biggest ones. People think that the parentage part, because it involves the court, that they will have to go to court and testify, that they might have to say some convincing reason that they're pursuing surrogacy. They might have to reveal personal information. But the truth is, the courts, especially in California, where they see maybe hundreds of surrogacy cases or thousands of surrogacy cases a year, they have a structure where they can very efficiently process the surrogacy cases, and they do not require, in almost all of the states, they do not require hearings where the intended parents have to show up, even telephonically. So when you do a surrogacy process, the legal part is invisible. We are drafting a contract. You do not have to meet the other party to sign the contract. You do not have to meet us in person. You can sign that often remotely on the internet, maybe with a web notary. And then when it comes to the parentage part, when the surrogate is pregnant and we have to file the paperwork in the court, you can sign all those paperwork electronically as well. We'll do the filing, and then you do not have to show up or testify in court. And we just get the judgment back almost like in a scheduled, timely manner. And another thing is that surrogacy matters are treated as confidential in the courts. So it's not the case that someone can maybe if you're a famous person or a famous business person, that someone could look up all the court actions and see that your name is filed and learn about your surrogacy. In most states, the court actions are sealed and confidential. That means only the parties to the case have access to it, and it won't be reported to anyone. So surrogacy is very much a confidential process in the United States.
California, as you mentioned, is known globally as a surrogacy-friendly state. What specific protections or precedents make it the golden standard for intended parents and surrogates here?
I'd say the first part is their law. So in a lot of states, maybe there's only about a dozen states that have laws on surrogacy that are positive. And California was the first state to actually put into law to recognize surrogacy legally. And some of the advantages in California are it doesn't matter whether you're single or married. It doesn't matter whether, even if you're a couple, if you're married, it doesn't matter if you are genetically related to the embryo. So you could have a donor, both the sperm and the egg, potentially. It doesn't require that you have a medical need for surrogacy. It doesn't require that you do a psychological evaluation. So there's a number of things that are like an advantage in California. Then the law also states that if all the things that are required for the contract are satisfied, you can get a judgment naming you as the parent, and that will be before the birth. So we commonly call that a pre-birth order. So if you receive the judgment before the birth, we send it to the hospital. The hospital will recognize it, and they would treat you as the parent in the hospital. That means you'll get a wristband, which lists your name with the child, so that you can access the nursery at any time. You get to fill out the birth certificate. You'll be mailed the birth certificate, and everything you discharge with the baby. Everything is the same as if you had given birth yourself. So that's one of the advantages, but there are a number of other friendly states. We're also licensed in Washington, which is very similar to California. There's a couple more limitations, but it's still a very smooth process. And other states like Illinois, they have a few more restrictions. So maybe it is that the fact that maybe because California has a favorable law, but very few restrictions, very few requirements, that's one of the leading reasons that it's the leader in surrogacy.
So for international intended parents, from Asia, Middle East, Europe, what are the top 3 legal considerations they need to prepare for when entering a surrogacy journey in the United States?
Well, one of the requirements that a lot of agencies or the surrogate's attorney will have is that they may require that the intended parent be present at the birth. So the intended parent should prepare by making sure they have a visa to come to the United States, so it'll be valid and they will be able to travel to the United States when the birth comes. Not all intended parents can come to the US, right? So in those situations, we do prepare a power of attorney, and we contact the hospital to make sure we have all their requirements met. And you'll have to find someone to have a power of attorney to take the child. But generally, most cases, the intended parents, they do want to come for the birth because it is a monumentous occasion, and they could have a chance to witness the birth and be part of the bonding experience right away. So we do encourage that our intended parents have their visa situation all cleared up. Some of the countries, they have visa waiver programs. We still suggest that they get a B1, B2 visa, because if it's an SD visa, they might have a shorter amount of time that they can be in the US. Some states do require, a state like California, Washington, Arizona, the birth certificate will usually issue in a couple weeks. But some other states that we work in, like Oklahoma, it could take 1 or 2 months. So you need to know about the state, and you need to be prepared to stay, because you have to wait for the birth certificate and you cannot get the passport until you have a birth certificate. Some countries do allow you to travel without a passport because it's your newborn baby, though. So That will be another consideration. I think the third consideration is probably the embryos, right? Most of the times, the surrogate is not going to travel to your country if your embryos are in a different country, unless it's Canada or Mexico. The surrogate will need a passport to do that, and sometimes the surrogate does travel abroad. But if we do that, we do need a declaration in most cases of the, the doctor that does the transfer. So if you're in a country where the doctor will be reluctant to sign any kind of declaration to admit that they did a third-party transfer, then we encourage the shipment of the embryos to the United States. Because we do have to tell the court that we're completely sure, we're medically certain that the surrogate is not carrying her child, but the child of the intended parents. So those would probably be the three things: the wait time for the passport, having your visa, and then being able to transport your embryos here, or being in a country where it's quite easy to do the transfer, and the doctor will not have an issue signing a declaration.
We had a case last year where there's a Middle Eastern parent. They had visa. On a precautionary side, they got the power of attorney so that in case if they miss, baby comes early, then they have someone to be present out there.
Yes, I definitely think there's a chance that a surrogate could always deliver a baby early, even if they do have everything lined up, like their travel plans that took to get booked. Babies do come early. They come when I guess they always come when they're ready. So if you do not have someone in the United States that can take care of the child, if you do not have a relative or friend who's willing to do that, your agency may be able to assist. Sometimes the agency workers or owners will take care of the child. Sometimes even the surrogate will agree to do that. We do not think it should be a very long time typically, so hopefully there'll be some way for you to come as soon as you're able to. But it is a good idea to have a power of attorney or someone that you contemplate will be a good power of attorney and make those arrangements should that happen. We can get a power of attorney prepared in the same day if needed. We can have you notarize that remotely and have that prepared. And we just need things like your identification so that we can prove to the hospital that we already have this judgment, and then you're just not able to come, and please allow this other person to make decisions regarding the child until you are able to.
Now, regarding the surrogacy agreement, what must absolutely be included in a surrogacy agreement to ensure both the surrogate and the intended parents are fully protected?
The surrogacy agreements are typically 50 pages or more. They're very complex and they do handle almost every situation imaginable. So I would say some things that are important. We need to discuss what would happen if there are birth defects, if there are developmental disorders, there are abnormalities that are detected when the fetus is developing. I think that's an important thing. Although it's extremely rare that these situations happen, we do address this, and it is important when you meet with your surrogate in the beginning that you are on the same page. International intended parents tend to have a much less restrictive view about abortion than many Americans. Many Americans may feel that that a fetus is a human life and they'll be reluctant to abort, although many surrogates believe at the same time it's not their child, so that they don't make that decision. So it's an important conversation to have, not just simply gloss over. Even if it's written down what the preference is on the paperwork you've received for the match, you should still verify. I want to make sure we are on the same page about what the abnormalities are. So, for example, what is it something that you would consider terminating the pregnancy for? Would it be Down syndrome? Would it be something even like that the gender is different than the PGS testing? So those are things that are very important to narrow down, to just pin down. The other thing that might also be surprising is that Not every surrogate agrees to vaccinations. So there is a trend that some Americans do not want to get vaccinated, that they think that it might, even the COVID vaccine, that was definitely an issue. And now it's quite difficult to obtain a COVID vaccine unless you have a medical condition and can get a prescription if you're a young person. So you want to talk about vaccines and just see if she's agreeable to things like the DPAP vaccine, the flu vaccine. What are the kinds of vaccines that you would want the surrogate to have? Anything that the doctor recommends, and is she going to agree to that? A third thing, well, we talked about being present at the birth. I think for the surrogate, it's important that she's adequately compensated before the pregnancy. So if I'm representing the surrogate, I will look at things like, is her monthly allowance starting at the time she signs the agreement, or is it only starting when she is pregnant? Because she is going to have a lot of appointments. She's going to have to do an embryo transfer. She's going to have to do some testing of her lining before the embryo transfer. And if someone's in California, a 10-mile drive or a 15-mile drive could be an hour or two, and it could cause a lot of waiting, missing a day of work or half a day of work. So we want to see that she does have some compensation before she's pregnant. And some women, if they're not successful after the first embryo transfer and they're not adequately compensated prior to their pregnancy, they may not want to do a second transfer because they feel this is not enough. This is more than I signed up for. We don't want to have that situation.
And regarding the cultural, because when it comes to international intended parents, there's also a cultural difference, not religiously importantly, but cultural. They're coming from a very different country. They have some certain requirements and criterias. Do you think that should be part of just a social conversation with the surrogate, or it should be a part of an agreement, like the points like eating habits and drinking habits? Some people who are coming from countries like Middle East, right? Should it be a part of contract, or is just the social understanding would go here?
No, if it's anything that affects the health of the child, or potentially when she delivers or she delivers prematurely, then it's definitely going to be part of the contract. So things like, we do have a section on not drinking, doing drugs, smoking, being next to secondhand smoke, if her spouse smokes, what he's supposed to do, those sorts of things. So I think it is important whenever it pertains to the health that we address that. If it's something about the diet as well, we do ask that she eat a nutritionally healthy diet. Some intended parents want us to put in there what she cannot eat, raw fish and deli meats and things like that, soft cheeses. Although sometimes, it can get to be too much. But we do like to have a conversation with the surrogate. Sometimes the surrogate will say you cannot do all these physical activities, horseback riding. We've had a surrogate that rides horses. We had a surrogate who plays kickball and she explained how this sport, how it would be safe, and other pregnant women had done kickball and that sort of thing. So it is enlightening to have that kind of conversation, because you don't want the surrogate to just agree to something and then she's going to, on her own, secretly do it. We want her to come back and say, I do get my nails done. What if I get my nails done this way? Or what if I, have a permanent in this trimester with a well-ventilated room and that sort of thing. Because if it's something that she wants to do, we want her to disclose it, and we want to work it out, find something that the parties agree to. And sometimes the intended parents say, I really don't want that, I expected her to be natural or whatever, then the surrogate will comply. But it is good as well, because you kind of get a preview of what this long relationship's going to be. The surrogacy contract is not a one-day contract like a sale of a car or a house. It's a potentially a year contract. the surrogate's going to carry for hopefully 9 months. So we do need to make sure the parties really understand each other and they discuss it. The parties are not supposed to discuss directly with each other, though. So once you have an attorney, we don't want the intended parents to be texting the surrogate, please accept this. It's really important. The attorneys can handle that. We can handle that pretty efficiently, and we'll explain what you tell us. If you do need help, sometimes the agency will act as an intermediary, but I think not directly contacting the surrogate during the negotiations is also important.
Sometimes it feels to an IP that I know the surrogate, I'm compensating the surrogate, we have a good understanding. Why are we becoming a gatekeepers? Like, for agencies, they feel like that. Sometimes they feel that for the attorney, like we have a good understanding, we can talk that directly. Legal advice, it is in the interest of both the parties where it goes through the intermediaries, preferably the attorney, and if not, then the agency steps in, because maybe that other party, for example, like, the IP can request something to a surrogate, and surrogate out of just politeness, it says yes, but if not comply it, because it was not discussed through the attorney, it's not in your legal terms, then that is where, you can't go and question, like, why not did it?
We try to do the process as quickly as possible so we don't feel like a gatekeeper. we don't, it's seldom that we're told that that they feel like we're a gatekeeper. I think I would remind the intended parents, when we work with an agency, nearly all the cases are going to get through legal successfully. Maybe someone will cancel because they have a change in circumstance, but it's seldom because of the legal itself, right? In an independent case, sometimes we see that the intended parents, because they don't have the agency, they are getting directly involved, talking to the surrogate, and then that can cause some problems because the surrogate will feel pressured. I think if you think of it as the medical clearance side, you're not going to be talking directly to the surrogate to try to get her medically cleared. There's nothing you can do. So if you just think of it similarly to that, there's not really anything you can do to speed up the legal. But if you do want us to speed it up, we will speed it up.
Sometimes when they do it independent, yes, it helps with the cost. Obviously agency comes with a cost, but at the same time, what we have seen when the parents, the IPs come to us after they have tried independently and they were not successful, or sometimes they just had a very bad experience, and sometimes they lose embryo because if you just go and find person on your own, feeling that you have done all your due diligence, but it's not being held by a third party in the middle, people have lost the time, the cases where they have lost the embryos because surrogates stopped responding. The legal as medical, as you said, and let the experts handle it. And your firm also works with diverse families. You work with same-sex couples, single parents, even the parent over 40 intended parents. How does the legal framework shift, or does it in these cases stays the same?
It's interesting because there are so many different types of intended parents, so many different reasons for people pursuing surrogacy. And in the end, the legal result is the same, but they're going to have a judgment recognizing them as the parent of the child. And that judgment will result in a birth certificate. And I suppose this is also something that a lot of intended parents don't know. The birth certificate is identical to the birth certificate if you gave birth to the child yourself. There's nothing on there that says there's a surrogate. There's nothing on the back page or anywhere that mentions that this is a surrogate birth. It's exactly as though if you gave birth to the child. So there are different states that have more restrictions, as I mentioned. Some may require genetic components, some may require that you be married, some may not allow single people to do the surrogacy. But if you do find a state that you are qualified to be an intended parent and be recognized, then your judgment and your birth certificate it's not any legally different than if you had given birth in the United States to the child.
Regarding the passport, so I think the birth certificate, does it have to carry the both parents' name? Let's say if it's a single parent or a single father does it require to have the mother name listed? And if yes, then who would be that?
I'm not so familiar with other countries' passports, but I don't believe the United States passport lists the parents, does it? I recall that the parents are listed. Um, and if they, even if they, I would say for a birth certificate, I do know, like, if there's no mother or there's no father, or there's two fathers or something like that, there'll be a blank if there's no mother, right? There'll be a blank if it's a single woman and no father on the father section. They won't list anything. There are ways to, do judgments in a different way, and that you can not, if you don't want to have it that way, there are other possibilities. But in general, there's nothing wrong with having a blank spot for one of the parents if you're a single person.
And as per US,
There,
you can get the passport with that birth certificate, the US passport.
yes, that's right. For now, I mean, the executive order of the president signed, that is not in effect. Nationwide, the courts have stopped that order from taking effect. At this time, I don't believe that court order is, appealed to the Supreme Court. So until that happens, there's not a timeline where we'll know what the result of that order is. I think it might have to wait until a court decision, then maybe it'll be appealed, but we'll see. If there's any updates, we'll be putting that on our website as well.
To extend on the same point about this, recently, President Donald Trump signed this executive order addressing birthright citizenship. Many intended parents are asking, how does this affect surrogacy, and especially for immigrants living in the US or for international intended parents coming here? Do babies born through surrogacy in the US still receive US citizenship at birth? I know the orders are still not executed, but what are your thoughts on that?
It's interesting because the Supreme Court recently ruled in the summer that the ban, so some of the courts, all the courts that have considered the issue, they say this executive order is not valid under the 14th Amendment, that birthright citizenship is part of the Constitution. So that went to the Supreme Court because that was stopped nationwide. And the Supreme Court says you have to do that through a class action. You can't actually cover the whole country. And so the same day, the ACLU and some other groups filed the class action, and then the class action granted the nationwide stop to that executive order again. But the executive order is not in effect. Should it come into effect, it would only come into effect if, like, the Supreme Court rules that it's okay for it to come into effect. And so that's not on the docket right now, so we don't know when that will be. If it's on the docket, it's potentially could be this year, next year that it could be decided, but more likely it will not be this year. So that means it would be safe to have, if you had a baby and the executive order stayed, then the baby will have United States citizenship at birth. If the executive order is deemed valid, and that's a big if, my thinking is that it will only mean until as long as the executive order is in effect, you cannot get the citizenship documents. So it may be that later on, if there's another administration that gets rid of the order, then those children who are born in the US could apply for the citizenship documents like the passport and social security number. It's also possible that the Supreme Court, even if it did rule in favor of Trump, will only decide that it doesn't cover, people who are visitors, or, it doesn't cover people who are actually documented legally present in the US. It might only apply to people who are not lawfully present in the US. But it's very complicated to predict, because any prediction about the Supreme Court is usually wrong. And and we cannot predict what they're going to do. But for now, the citizenship is safe. I will say in the past, we have had during COVID, there's a long period of time where the passport offices are closed and you could not get a passport. It used to be you could get a passport in 1 or 2 weeks, right? But if the passport offices are closed, no one could get a passport, or it could take months to get a passport. And people were still having babies during surrogacy because this was not expected. And in those situations, they were able to find a way to bring the babies back to their home countries. So should Trump Trump's executive order be considered constitutional? I think all the countries will have something to allow their citizens to bring their babies back, because almost every country has people working here on work visas, student visas, and they will have situations where their citizens will be giving birth. So it won't be the case that your baby will be stranded, and that it will not affect the state law on surrogacy. So you will still be the parent. That is not going to be in question. The birth certificate will still be the state birth certificate. It will not change. So it's really a question of passport and citizenship in the future. We're hopeful that it'll be a rational Supreme Court decision, and this will not be something we have to talk about again.
I think the very important point that you shared, and I think that gives a lot of confidence and answers a lot of questions, because for international IPs, that's a concern. Not mean that would my baby be a citizen or not, but would I be able to take the baby home? But the birth certificate doesn't differentiate that it's a surrogate baby or it's your baby. So birth certificate is like you gave the birth, like it's your baby. So that's not where they should be worried. Even if this order goes through, I think is that you will still be able to take the baby home.
Yeah,
Citizenship or not would be a separate question.
yeah.
I don't care about citizenship, but would I be able to take the baby home? As like, yeah, I think that should be regardless if that executive order pass or not.
Yeah, and the answers for those situations may be more complex, and we'll have to speak with that person individually, because there might be an individual plan that we'll have for that person, depending on their situation. But we've always been successful with the parentage action. We were successful during COVID, even when courts were closed. We found a way to get those judgments and not ever have a baby born and not a judgment in place, or at least a judgment in place within a day or two. So we'll be very conscientious to make sure that this situation, it's not any kind of unexpected thing, will be managed.
Term that many people hear but don't fully understand is this parentage order. Could you break down what it means and why it's such a crucial document for intended parents?
We commonly call it pre-birth order, and it's sometimes a post-birth order in some other states. It's an order that says, it declares that the intended parents, the people who are named in the surrogacy contract, they are the legal parents of the child that is to be born from the surrogate. And so when the surrogate gives birth, this judgment usually is given to the hospital, so the hospital knows this is going to happen. They're not going to think that you're a stranger or a friend or family member of the surrogate. You are the actual parent. So when that judgment's in place, we send it to the hospital. We get some confirmation they received it. They don't have any issues with it. And you'll just be treated as the natural parent of the child. You are the legal parent. You're the natural parent. And you'll get to do everything with the child. You won't be restricted to visitor hours. You can discharge with the baby. You don't need the surrogate's permission. You can make the medical decisions for the child. All of that is going to be specified in the document as well. You are also responsible for the medical expenses of the child. With all those things, the judgment, it's important because you'll have to have multiple copies, because you may need that judgment the hospital is going to take the judgment. They'll send it to Vital Records typically. They'll need like an original copy. You may want to have an original copy for safekeeping. In some countries, they do want to see the judgment as well, so you'll need some copies of that. So the judgment, interesting thing is, even in countries where surrogacy is legal, some of these countries have processes in place where they will accept the judgment from the United States. And so, for example, I think France, surrogacy may not be legal in that country, but they do accept judgments, the surrogacy judgment, and they may require like a post-birth judgment. So sometimes you may want to contact the lawyer in your country. I think in general, you will want to try to contact the lawyer in your country and find out what that process is. If there's any specific language that we need to do or special processes, we'll include that in our pleadings so that, we will have something that will be in compliance with your home country if it's needed.
Finally, for intended parents, choosing an agency, importantly, the legal counsel, what are some red flags they should look out to avoid costly mistakes when they're choosing a legal counsel?
I think it's important that the agency allow you to have a choice. So if you only have maybe one choice, you may want to ask for more choices so you have a chance to investigate that. But some of the things that you can look at to tell if an attorney is qualified are the memberships they have, the number of years they've practiced, what law school they went to, the number of cases that they do. So we do several hundred cases a year in surrogacy and gamete donation. And almost since like our first year, we've always had more than 100 cases. So that means we are able to do our cases efficiently, but at the same time, we're very successful. We're going to still treat your case individually. We're still going to review the contract with you. It won't be a paralegal or a legal assistant, or it won't be just by email. You'll actually meet with us over Zoom. You have a chance to have all your questions answered. You can make changes to the contract. And as long as the contract takes, we'll work on that contract. For red flags for the agency should say who the owners are. The agency should be, you can be able to review their background. You want any successful cases they've had. In our case, we have over 125 five-star reviews. I think that might be the most of any attorney in this field. For agencies, you definitely do want to get to know the agency owner, make sure she's accessible, because I think you do want someone who's definitely there when you need them. That's very important.
Absolutely. And as you said that, and we know this, the surrogacy journey is not buying a car or a home, which is like a one-time transaction, few days or few weeks. It's a long journey. And all these, kind of stakeholders in this journey, which is your attorney, your agency, your surrogate, all have to be on one page, available, accessible. You can communicate things more easily, and I think when more openly, especially for IP and the surrogate, right? They should be able to reach to agency, tell their part of the journey or where they need more help. And as an agency, we need to be available. So rightly said, it's like, and then same goes for the legal, because I think the most important thing after having a baby is these legal documents, because you have a baby, but how you get the baby to you is where the legal counsel is very important. Ralph, this conversation has been so insightful. You have shown us that while surrogacy is an emotional journey, it's the legal protections that give families peace of mind. Thank you for sharing your expertise with us today.
Thank you, Dr. Mathur.
Thank you for sharing your expertise.